single day.
Miami-Dade just lost her appeal to Supreme Court in landmark First Amendment case. Medium by Grant Stern. June 4, 2018. The Miami-Dade County State's Attorney just lost a major ruling in front of the Supreme Court. The Supreme Court declined to review Mcdonough v. Fernandez-Rundle, the landmark appellate case which Catherine Fernandez-Rundle lost last year, that affirms citizens' rights to surreptitiously record the police in the state of Florida. It is case 17-1034 on the Supreme Court docket. Justice has clearly been served in this case, says Dr. Eric Mcdonough, the plaintiff. Finally, Dr. Eric Mcdonough became a plaintiff against the Miami-Dade State Attorney when he surreptitiously recorded a meeting with the City of Homestead's Chief of Police Alexander Rolle to file an internal affairs complaint after one of his officers, Alejandro Murguido, arrested him in retaliation for filing an earlier complaint. He published his meeting with Chief Rolle online, leading Rundle to send him a letter threatening prosecution, which gave him standing to sue. It proves again that a citizen can fight City Hall and win, even against the overwhelming resources of the 300 lawyers at the Miami-Dade State Attorney's Office, says Mcdonough, and the Florida Attorney General's Office. We are pleased that the Supreme Court denied certiorari review in this case, said Amir H. Ali, the Georgetown law professor who represented Mcdonough at the Supreme Court on behalf of the MacArthur Justice Center in Washington, D.C. We look forward to a prompt resolution in the District Court, says Ali, based on the 11th Circuit Court of Appeals decision. More importantly, the recording of Chief Rolle can be used against him in Dr. Mcdonough's pending complaint that led to an Florida Department of Law Enforcement, FDLE, investigation and in any civil matter. He's not the only one impacted by today's ruling. The Miami-Dade State Attorney, Mrs. Fernandez-Rundle, sent a similar prosecution letter to then Miami Herald journalist Jim DeFeet in 2005, says Dr. Mcdonough, who writes online under the pen name Doc Justice and on his widely followed Facebook page, True Homestead. DeFeet is a journalist at Miami's CBS 4 TV station Today. Public officials under Florida law have no expectation of privacy, and under the state's wiretapping law, it cannot apply to recording them, including the police, says Dr. Mcdonough, who recorded Rolle inside his office at the police station. Therefore DeFeet's case falls under the same body of law, meaning that he was dismissed from his job, and criminally investigated by that same office for a felony, without any basis in the law whatsoever. Now, the case will return to the 11th District Federal Court in downtown Miami, Florida. The trial court will have to issue a new ruling on the plaintiff's original motion for summary judgment in Dr. Mcdonough's civil rights lawsuit, which incorporates the appeals court's decision. Now that they've taken it to the Supreme Court, he says, the decision will be published, and it has become the law of the land here in Florida. You are now free to secretly record the police, as long as they're performing their official duties. Complete SCOTUS case records.
Fernandez-Rundle, Mr. Mcdonough.
Good morning, Your Honors. My name is Dr. James Eric Mcdonough. I'm here today representing myself pro se. My oral arguments are structured around the three cases cited by this court. Pell and Saxby relate to prison policies restricting the press from interviewing designated inmates, and Garrett relates to a prison policy restricting the press from recording executions. First, the uniting concept of these cases is that restrictions were constitutional, as members of the press have no special right to gather information not generally available to the public, and the press had greater access. By comparison, Florida Statute 934 does not grant special rights of access to the press. Further, I had no right of access not available to the public, as officers can freely invite anyone into their office and often do. Second, Garrett comparing itself with Pell and Saxby held, as in those cases there is no effort by prison officials or authorities to conceal conditions at the prison or inhibit press investigations of those conditions. In comparison, Chief Rolle attempted to conceal the actions of his officers and inhibit investigations against them. Third, Pell established the balancing test, i.e., that free speech rights must be balanced against the state's legitimate interest. The legitimate interest in Pell consisted of maintaining the proper and safe operation of prisons. By comparison, recording rights must be balanced against the state's interest of maintaining conversational privacy.
Mr. McDonough, let me ask
Yes, sir.
you this, and it seemed to change from the complaint through your last brief. What exactly would you have this court say? Let's assume, and I assure you it's only an assumption at this point, that we wanted to say something in favor of your side of the case. What exactly are you looking for?
I would ask for a declaration that the First Amendment protects the right to record police officers when they're acting in the performance of their official duties.
Okay, so if a police officer is talking to a confidential informant, you have a right to record that conversation.
No, sir. I should clarify
Here's my problem, Mr. McDonough. That's the kind of thing you ask for on public property, public official duties and that sort of thing. But that's far, far too broad. I mean, we sit as a court to decide disputes, concrete, specific disputes. And when somebody is saying, in the future, I want to do whatever the First Amendment allows me to do, we can't get a grip on that. Now, to the extent the relief you're asking for is, I want to be able to do what I did on this particular occasion in these particular circumstances at this particular location, I can understand that, and we can deal with that one way or the other. But record police officers when they're performing their official duties, that's way too broad for us to say anything about, or for us to even know that you've got a real dispute about that.
To clarify that, I wanted to be able to record police officers in the performance of their duties when I'm a conversation to the party, separate from a situation where a police officer could be talking to a confidential informant, which I'm not a party to that conversation. I don't think I would probably be able to record that. And I wasn't asking for any special access. It's just if I'm lawfully present in part of the conversation, I think that I should be able to record the activity.
Well, the question is not really whether you should be able to record it, is it? I thought the Florida statute only prohibited covert recordings where there's a reasonable expectation of privacy. But in other words, it doesn't say that you can't walk in with a tape recorder running in the presence of the police officer and in his plain vision and ask him questions with the tape recorder running, does it?
Your Honor, the Florida Statute 934 doesn't address open versus surreptitious recording.
Yeah, but the Florida Supreme Court has, and it said whether there has to be a reasonable expectation of privacy. And obviously, if you've got a tape recorder running when you're talking to the chief, he doesn't have a reasonable expectation of privacy. So what you're are you asking us for a ruling that you can covertly, unknown to the chief, record the chief in the same circumstances in which you recorded him this time? Is that the relief you're seeking?
Yes, sir.
All right. Are you seeking anything beyond that relief?
Just that it would be declared that recording police officers in the performance of their duty when you're a party to the conversation and otherwise lawfully present, you would have that right, and to enjoin the state attorney from.
When you say recording, of course you can record it if you're doing it openly and he knows it and he sees it and he keeps talking. But you're asking us to allow you to do it when he doesn't know you're doing it, correct?
Yes, sir, but the state in their letter to me didn't address open or closed or surreptitious recording. They only said that if I was to record again without getting the consent, I would be prosecuted. They only addressed consent.
Are you also looking for, it was unclear from my reading of the record, are you also looking for an ability to post, on YouTube or wherever, additional excerpts without experiencing the threat of criminal prosecution.
Yes, sir, Your Honor. I believe the right covers both the recording and the dissemination or the publishing of that recording. And where I published excerpts of my recording, which led to the letter, I've refrained from publishing other sections of that overall recording in anticipation that it might lead to prosecution or...
Where did you ask the district court for a declaration that you had a constitutional right to post the excerpts that you hadn't posted of the recording that took place in the past?
At the trial, at the district level, Your Honor, we never addressed the publishing. It only got to...
So the district court wasn't given an opportunity to rule on that is my concern. And the letter that the state's attorney sent you doesn't mention anything about publishing what you've already recorded. She said a future violation prohibits any party from intentionally intercepting any wire, oral, et cetera, communication. We're bringing this to your attention to prevent any further violation. You read that as meaning that you can't do anything with what you've already recorded?
I don't read the state's letter to explicitly say that, but the statute says that the statute where it says recording is illegal, it also makes it illegal to publish. So if my recording was unlawful, the publishing would be unlawful. And I did not get that from the state's letter, but just from my interpretation of the statute.
Okay, let's hear from Mr. Funes now, and we'll give you your full 3 minutes in review.
Thank you, Your Honors.
Mr. Funes.
May it please the court, my name is Freddie Funes. I'm amicus curiae, and with me is Jared Reiling of Gelbert, Schachter, and Greenberg. Your Honors, where a citizen is having a conversation with a public official about matters of public concern, state's attempt to prohibit that citizen from gathering information about that very conversation implicates the First Amendment.
Of course, he can gather the information. The question is whether he can covertly record the conversation.
Right, and I think basically Blackstone, which we said in the brief, basically determines that prohibiting the surreptitious recording of a conversation implicates the First Amendment.
I thought Blackstone was a public meeting.
Well, it was a public proceeding, but at the same time, in a sense, so was this. Chief Roll was meeting with Dr. Mcdonough as a public official. They were not there to discuss their weekend plans. They were there to discuss complaints that Dr. Mcdonough had about the police department. To say that somehow one meeting is public and another one is private only because the number of people allowed into the office, it seems not to be a very good distinction to make, at least when it comes to the implications of the First Amendment. On page 120 of Blackstone, this court specifically noted that the reason the First Amendment was implicated was because when a government official stops a citizen from recording the public official's conduct or words, it stops or it inhibits, in some ways, the right of that citizen to gather the information and then disseminate it in the way that the citizen would like to.
What about a mediation? Big civil case, you've got a mediation, and somebody covertly records the mediator and the opposing party's statements, the whole business.
A mediator between the government official?
No, plaintiff and defendant. You've got a court-appointed mediator. Let's bring the court into it. And one of the parties goes in and records everything.
I mean, I would say to that mediator is not really a public official. I mean, to be sure, he got appointed by the court on the request of the parties.
Well, suppose the judge appoints the magistrate judge to do the mediation. That happens sometimes.
Well, when it comes to that, Hastings in particular, this court has applied the reasonable time, manner, place restrictions, but said, look, the court has, and the Supreme Court has also said this, there are very important interests, governmental interests, in keeping some things confidential when it comes to the court. For example, the public doesn't have the right to ask for exhibits. That's United States versus Gurney, I think 558 F2D 1202. Doesn't have the right to get the bench conference between the judge and the lawyer.
Doesn't have the right.
But you know all this in advance because the rules there, you go on the website and you look at the court's rules, so you know what the ground rules are, isn't that right?
Well, even in United States versus Hastings, there was already a rule in place about the right of the media to record and broadcast a civil trial or trial, and this court applied the reasonable time, manner, place restriction and just said, look, this is a reasonable restriction. There is just important interest, especially when it comes to courts and litigation, to make sure people aren't acting for the camera, that witnesses aren't acting for the camera, and this is it's a tailored rule that furthers that governmental interest. Here, there is no sort of real privacy interest. Dr. Mcdonough was speaking to a public official.
But it was in an office with a closed door.
Sure, but he was invited to that office to discuss an issue of public concern. Chief Roll could have denied access from the beginning if Dr. Mcdonough wanted to go in to discuss it under a traditional public framework.
What if, that statement you just made, what if the chief said when the plaintiff walked in, now, I'll be glad to talk to you at length, answer any of your questions, engage in good discussion with you, but not if it's recorded. Are you recording this? And suppose the plaintiff said, no, I'm not, and he recorded it. Is that protected by the First Amendment?
Well, I think the recording would be protected by the First Amendment. The lying to a public official may not be protected by the First Amendment, or if it is protected by the First Amendment. I mean, there are laws that say, when I sign certain things, I verify the truth.
He has a right to misrepresent, under the First Amendment, to misrepresent to a law enforcement officer or whoever, for the government official, whether he's recording the conversation or not. It's a constitutional right to lie about that.
Well, I mean, it's a different thing to say someone has a First Amendment right and that whatever the government's restriction on that application of First Amendment right survives some sort of scrutiny. So, for example, lying to a police officer, I mean, it's a statement, speech, so the First Amendment is implicated. That is not to say that a regulation on barring criminal...
Well, suppose the statute said it makes it a crime to lie to a public official about whether you're recording a conversation you're having with him relating to public business. Is that unconstitutional?
I guess that it might be unconstitutional because it is forcing a type of speech. So then you would have to look at it to see whether it survives scrutiny.
How's it forcing a type of speech?
Well, you're telling somebody to say something. On the other hand...
No, all you're asking is, are you recording this or not?
Right.
If the person says, I don't want to answer that, then you don't have the conversation with him.
I mean, I would guess, and I haven't done any research on this, but that it does implicate the First Amendment, but any sort of law that requires someone to disclose truthful information to the police in terms of investigation or because the police fears any sort of safety would survive First Amendment scrutiny and would be constitutional under the First Amendment. But again, the question is, the question you're getting at there, Your Honor, is sort of what level of scrutiny applies and not whether the First Amendment is actually implicated. And I think here under Blackstone it is implicated, especially on page 120. And so under Blackstone, this court has already said that you have to look for a reasonable time, place, and manner restriction. And I agree with the government, with the state, that privacy is a significant governmental interest. It's not clear to me that this statute is narrowly tailored. In fact, in ACLU of Illinois versus Alvarez, the Seventh Circuit sort of considered a very similar statute, and the Seventh Circuit underscored that that statute was probably not narrowly tailored because, for example, Dr. Mcdonough could have, the day he had the conversation with Police Chief Roll, could have told his friends the substance of the conversation, could have blogged about the substance of the conversation, could have in many ways disseminated the conversation. And so once you get to that status of whether this is narrowly tailored law, the answer is no, at least when one of the parties to the conversation has decided either from the beginning or afterwards that he wants to disclose the substance of the conversation.
Let me ask you this, and I know you weren't counsel throughout, so you're in no way responsible for any ambiguity in the record about exactly what the plaintiff is seeking, but what do you understand? If you were writing the last paragraph of an opinion and it was in favor of the plaintiff, what should it say specifically? We can't say don't violate the First Amendment.
Sure. I think there's two possible ways, honestly, this court can go. The first is the one that Dr. Mcdonough sort of mentioned, when a citizen is having a conversation with a public official, and it's part of that conversation, that citizen has the right to secretly record the conversation. Just because it is about governmental affairs, it goes to the court of the First Amendment, and also it's a medium and a way of disseminating the information quickly. That being said, in the complaint, you could almost read it as Dr. Mcdonough just seeking an as-applied challenge to the letter sent by Catherine Fernandez-Rundle's office in the Miami-Dade County, which interpreted Florida Statute 93403 to prohibit any sort of recording when another party does not consent to it, which is honestly broader than what I think the Florida statute actually is. And in that situation, the record would support that Dr. Mcdonough does record police officers in the street when they interact with other citizens, and does support that he likes to record in committee meetings.
That's public conduct out in the street. Nobody has, the Supreme Court of Florida, whether it's in the statute or not, has authoritatively interpreted the statute of requiring a reasonable expectation of privacy on the part of the, quote, victim, end of quote, of the covert recording. So if a police officer is out in the street engaging in conduct or talking to people out in public, there is no reasonable expectation of privacy.
I agree, Judge, but I would just say that the letter, which threatened prosecution to Dr. Mcdonough, did not mention reasonable expectation of privacy.
Well, let me ask you this. Suppose a state's attorney sends a letter that says something is criminal under a Florida statute that isn't criminal under that Florida statute. Is that enough for ask a federal court for declaratory judgment about whether that falls under the Florida statute or not?
Depending on the position that the state takes, my guess would be that this court could just say, look, the letter, the threatening letter sent is unconstitutional, but not necessarily the Florida statute, since the letter misinterprets what the statute actually says. I understand, Your Honor, it is a wrinkle in this case.
Yeah. It's an unusual case, and I know, of course, that you are serving as amicus here, and we deeply appreciate that. It's helpful. It is, in fact, helpful.
Thank you, Your
Now,
Honor.
we'll hear from Mr. Pratt.
Good morning, Your Honors. May it please the Court. My name is Jordan Pratt on behalf of the appellee. I'd like to pick up first, Chief Judge Carnes, where you, in that line of questioning, asked both appellant and amicus about the nature of the claim that's being asserted in this case. And I'd like to offer what I think is a helpful...
Before you get to that, why... The police chief has had a series of complaints about police misconduct. They are not on their face frivolous. The claims are that after Mr. Mcdonough confronted a police officer about misconduct on the streets, the police targeted him. The chief invites him into a meeting. The chief had no obligation to do this. He comes in ostensibly to discuss the problem he's having, Mr. Mcdonough. Where does the legitimate expectation of privacy come from?
So to the extent that this is a question about the reach of the statute...
No, the question is what it is, so please answer that.
Sure. So in regards to the statute, the reason why he had a reasonable expectation of privacy, the Florida courts have articulated a very fact-dependent test, which is essentially the CAT's reasonable expectation of privacy test. And among the factors that the courts consider are the location in which the conversation took place, the circumstances under which it took place, the numbers of conversants, and other facts. In this case...
So the chief could not possibly believe that this was a meeting that did not have a extremely important public dimension to it.
I think that's probably fair to say, but the statutory language doesn't actually talk about a reasonable expectation of privacy. It talks about a reasonable expectation that a conversation is not subject to recording under the circumstances.
What does that mean? How could a citizen know that?
Well, I think a reasonableness standard in law, while it certainly is fact-dependent, is fairly understandable by members of the public, and certainly when we have a situation in which...
I don't understand it.
Well, according to the factors that the Florida courts have specified that courts are supposed to consider in determining whether the statute applies, when we have a situation where a meeting takes place behind a closed door in an enclosed area, especially a private office, where there are only 3 conversants for the majority of the conversation and then 4 for an additional part of the conversation. All of those factors heavily weigh in favor of finding that the police chief had an expectation that that conversation would not be subject to recording.
If the police chief is convening the meeting, isn't it incumbent on him to simply set the ground rules?
Well, I'm not, in terms of recording, I'm not sure that that's the case because of the Florida statute. I think the Florida statute sets the ground rules.
Could Mcdonough have, could the plaintiff have taken verbatim notes?
Sure, under the statute he could have. Now, if the chief had wanted to...
What's the difference between taking verbatim notes and recording it?
I think there's a very big difference, and I think even this court in its own rules would acknowledge that there's a difference between recording and note-taking. The Supreme Court has certainly acknowledged that there is a difference. The Supreme Court's rules allow note-taking during oral argument, but not recording. Recording is different. Recording is able to be surreptitiously deployed. It is uniquely accurate, but as a consequence of its accuracy, it also is manipulable. And in this case, the plaintiff did testify in his deposition that he spliced the recording to juxtapose the police chief's statements against each other. So recording, though unusually accurate, can also be used, especially when spliced, to take statements out of context. But regarding just the privacy interests, because of its accuracy and deployability, it poses a much more heightened threat to privacy than does, for instance, note-taking. And I think, although amicus points to the statute's allowance...
Was the content of this discussion private?
Under the statute, the police chief had a reasonable expectation that this conversation would not be subject to recording, for all of the reasons that I listed, the closed door where the meeting occurred. But if I may, I would like to get back to Chief Judge Carnes's line of questioning about the nature of the claim in this case, because I think that's really the threshold issue that should inform the court's analysis, both of the standing issues that are raised and also the merits. I think a helpful way to look at this case is that, yes, the plaintiff did claim in his complaint and described in his deposition and also in his appellate briefing a broad right to record public officials, namely police officers, in the performance of their duties during conversations to which he is a party. However, the only aspect of that claim that he has preserved is the aspect of that claim that relates to the only factual scenario that he has employed when raising an argument on his claim, namely the facts and circumstances of his recording in Chief Roll's office. So regardless whether the plaintiff in fact intended to claim a broad right to record police officials, regardless where those conversations take place, by presenting his claim in an argument that puts at issue only that set of facts, I believe that he has waived any possible applications of his as-applied claim aside from recording in a police
so we've
station.
got to really circle back and take another look at his pleadings.
And I think I should specify he was represented in the district court. Okay. So I think that that's really the answer to the threshold question of what is this case. So then we get to the question whether the plaintiff has demonstrated standing. And it's critical to note that at no point in this litigation, in the pleadings, in the moving papers, in the summary judgment evidence, did the plaintiff ever assert, allege, or argue that he intends at any point in the future to again record inside a police station under circumstances similar to the circumstances of the ROLLE incident.
But the state has said that if he publishes more, he's going to be prosecuted.
That's correct. The letter, in paragraph 13 of his complaint, plaintiff, I think, correctly understood the letter to confine itself to the facts and circumstances of the ROLLE incident and any future incidents that occur under like circumstances. So there was some discussion, I believe, between amicus about whether the letter failed to mention a reason.
Get on to another better argument, because I find your standing argument essentially frivolous.
Well, if that's the case, and if this court disagrees and believes that this court is justiciable, then on the merits, the claim should fail. Now, again, if we're viewing this case through the lens of the argument that he has consistently asserted throughout this litigation, the argument based on recording inside of a police station. We confront first the threshold question whether there is, under the First Amendment, a right to record police at all. And I would like to note that the statement in Smith is dicta, but we also concede that it's very clear. And the state attorney is willing to operate on the assumption, for purposes of this case, that Smith accurately states the law in the circuit, namely that citizens have a right to record what police do in public places.
In God's name, wouldn't they? I mean, the Florida statute says reasonable expectation, and you say the Florida Supreme Court has said that means expectation it won't be recorded as opposed to the privacy generally of the conversation. But why would anyone in this day and age where everyone's walking around with a video camera on their belt or in their purse in the form of a cell phone, would a police officer have a reasonable expectation he could do anything in public and not be recorded?
I think there are hard questions that courts have confronted in analyzing whether there is a right at all to record police, at least in public places.
I thought the Florida Supreme Court had said it requires a reasonable expectation of the officer, objectively reasonable, that it won't be recorded.
Yes.
What law enforcement officer would expect, what reasonable law enforcement officer, would any reasonable law enforcement officer expect that he could do anything in public and not be recorded?
I would direct this court's attention to this court's unpublished opinion in Miggott. Now, that opinion is unpublished, but it dealt with a situation in which an individual who had been stopped on a public street by a police officer for a moving violation recorded that traffic stop. And this court, after surveying the Florida case law, held that the arrest in that case was appropriate because the statute did embrace recording in a traffic stop. Now, regardless what this court might think about the reach of the Florida statute in various hypotheticals, things occurring in public places, and of course the Florida courts have made clear that the location in which a conversation occurs is a factor, an important factor, in determining the reach of the statute. Here we have a situation in which a conversation took place behind closed doors in the interior of a police station, in the interior of a police chief's office.
But if I'm a public official and I invite someone in who I know is raising legitimate or arguably legitimate concerns about my official behavior, why would I, without more, why would I, how could I expect that this is a private conversation? And this individual is publicizing his disagreements with my office and the way it conducts its business.
The state attorney does not deny that there are things that would occur inside a police station and conversations that take place that would be of public interest. That's not the state attorney's contention. The state attorney's contention is that in this case, the reach of the statute is dependent upon several factors, including a closed door, the nature of the meeting, where it took place inside of an office, the limited number of conversants.
What about the significance of the invitation? That to me weighs heavily.
Well, in terms of the First Amendment analysis, I would like to discuss the authorities that this court directed our attention to, because I think that they establish...
Come on in, let's talk. Let's talk about this problem we have. How could I reasonably expect that this wouldn't get out? It seems to me that the reasonable take on this conversation is that the police chief wants an opportunity to tell his side of the story, his side of an important public controversy. Why would I expect, if I were the police chief, why would I expect that this man is not going to go right outside and tell everybody you'll listen what happened in the meeting?
The first thing I would say is that the Supreme Court, the Florida Supreme Court, has articulated a reasonable expectation of privacy test, but it also has tracked the statutory language. And the statutory language is more particularly, I think that the Florida Supreme Court is using this CATS test as kind of a shorthand. The statutory text is that an individual must have an expectation that the conversation is not subject to recording, and that expectation must be reasonable. And I think especially when viewed in light of the statutory text, while the police chief might expect that perhaps certain aspects of the conversation might be disclosed, I don't think that there are any circumstances here that would negate an expectation on behalf of the police chief that this conversation would not be recorded.
Let me ask you this. One of my frustrations is trying to find out what the Florida Supreme Court said. You don't cite a single Florida Supreme Court decision in your brief. None. What's the best case from the Florida Supreme Court in support of your position? Or best two, or best three?
Sure. So we did only discuss Miggott, which in turn surveyed the Florida case law. But for Florida Supreme Court decisions, and forgive me, Your Honor, I think I have a list of them here. I want to
well,
make sure that I get this right.
If all of them are in Miggott, that's fine. I just at least didn't see the spin.
Yes. So Miggott extensively discusses the Florida case law from appellate courts and also from the Florida Supreme Court. And then applying that case law to the facts in that case determined that the statute properly would have embraced or prohibited the conduct at issue in that case, which was a traffic stop recording. But in terms of the merits, if this court believes that this case is justiciable, the state attorney recognizes that the Supreme Court has found within the First Amendment some right to gather information. But that isn't at issue in this case. As this court explicitly said in Hastings, to treat the right to gather information, recognized in Richmond newspapers and Globe newspaper, as a right to record, misconceives of the nature of the right that was recognized by the Supreme Court in its information gathering cases. In other words, the Supreme Court's information gathering cases spoke about a right to attend, be present, and observe certain courtroom proceedings. It did not talk about a right to record those proceedings. And this court directed counsel's attention to Supreme Court cases and a former Fifth Circuit case, Garrett, which established the proposition that simply because an individual is afforded a special privilege of access, not afforded to the public generally, and I think that's what happened here. I don't think that members of the public are free to come and go to the police station, and certainly not the police chief's office. So to the extent that an individual is given access to information that is not generally available to the public, such as a private conversation with a police officer, that individual cannot invoke the First Amendment as a Pandora's box to then open or force the government to provide whatever type of information gathering he deems.
If he puts up more of this information on his blog or his website, is he susceptible to prosecution?
Yes, the statute prohibits not only the intentional interception of certain oral communications, but also the publication of oral communications that were obtained in violation of the statute.
He hasn't.
He hasn't brought that claim.
I tried my best to figure out. The claim has kind of evolved and then devolved and then evolved again throughout the proceedings, but I didn't see anything in this record about publishing what he's already recorded and requesting relief about that. Have I overlooked something?
You have not, and if you have, then I have as well. I haven't found anything on that. So, all right, well, thank you very much, Your Honor. We ask for either vacature and dismissal or affirmance.
Okay, thank you, counsel. Dr. Mcdonough, you've got 3 minutes.
First, I'd like to just really quickly address the surreptitious argument. The Northern District of Florida held in Bacon v. McKeith, and it was a case where a person had recorded a traffic stop and then let in open court at the...
That's out in public. Why do you think you had a right to go into this man's office in a closed-door meeting and record it?
The binding law for Florida is Edwards versus Department of Consumer Services and Agriculture, and that case specifically held that no government official had an expectation of privacy or privacy privilege in Florida. The facts of those cases were very similar to the facts of this case. It was a subordinate officer went to his sergeant supervisor's office in a police department and recorded the conversation. There was a couple other officers also in the supervisor's office, and the court held the factors belying the expectation of privacy therein were the location of the meeting, which was a sergeant's office in a police station.
What case is this again?
Edwards versus Department of Consumer Services and Agriculture. It was cited in my brief.
It's in your brief.
Yes, sir. Yes, sir, Your Honor.
The court found there that there was a violation of statute, didn't it?
No, sir, Your Honor. The subordinate officer who had recorded the other supervisory officers in that meeting. They had tried to prosecute him, and the case was dismissed because there was no expectation of privacy. And like I said, in that case, the court held the factors belying the expectation of privacy were the location in a sergeant's office in the police department, the number of people present in the office, 5, and the manner of the speech, which was a complaint. In comparison to the instant case where there was only 3 for part of the conversation had 4 people present. The chief told 2 people about the meeting out who were not present in the meeting, and it was written as part of the official record. I have no idea how he could possibly claim an expectation of privacy in that meeting. Also, I'd like to say the state likes to argue that public places, and we've addressed this here, and I understand where in public, when we're out in public, there's no expectation of privacy. However, the binding precedent of Smith held the right to gather information, held the First Amendment protects the right to gather information about what public officials do on public property, specifically the right to record matters of public interest. The plain language of Smith says public property, which is different than a public place, and the police department is public property. I know the facts of Smith, they were out in the public, but the broad holding of Smith says public property.
Well, you say it's a holding. Smith couldn't have held that any time somebody's on public property, you have a right to covertly record the conversation. It just could not have meant that. That would mean in a closed-door hearing on internal affairs, for example, which by law is usually, at least the initial hearings are confidential, that you could record it. It would mean that you could covertly record a conversation between a confidential informant and a police officer. And it can't be that anything that goes on inside the police station, you have a constitutional right to covertly record. That's just far too broad. Your best argument is, and really I think the only claim that has been consistent throughout here is, I have a right to do what I did. I can do that again in the future, and they shouldn't threaten to prosecute me for doing what I did in this case. I'm just viewing it from, I know you would like us to give you 4 pages on what you can do and can't do, but that's not the way the courts work. We have to have a specific defined dispute that we can rule on. There are, in fact, provisions in the law for facial unconstitutionality, but those almost never work, and the reason they didn't work, and you were right not to appeal that part of the case, is all you got to do to defeat a facial constitutionality challenge the state has to do is come up with one case that fits within the statute that it wouldn't be unconstitutional to. And I don't understand you to be arguing there's no way this statute can ever be constitutional. You're just arguing it's not constitutional to what I want to do, as I understand it. So that's where we are, and we keep going back to the meeting with the chief and the door being closed, but other people being in there and so forth and so on. We have to have something to grab, to decide. And the only specifics that you've given us that we can really deal with are what happened in that case and your statement somewhere in the pleadings that you wanted to do it again, basically. But that's where we are. But we appreciate the arguments, and again, appreciate Amicus's contribution. And it's an unusual case. I thought it was well argued, and we appreciate all of y'all making those arguments. We'll take that case under submission and then take up.
Hey, Sheriff County, this is Sheriff County COPWATCH. I am using any video here with under fair use if you have criticism, reporting, teaching, etc. And please donate. I do not make money from YouTube, and there are different ways to donate in the video links. Thanks.